And please the court, I'm Ann Allison, I represent the appellant who is often referred to as Bunny. That's her kind of name with her family. Anyway, this is an appeal of a writ of possession, non-final order, and that was the time in which our client discovered that this whole case had foreclosed. When her sister, who was the co-owner of the property, basically had to move in with her in Arizona because she was ejected from the property here. So then she found out about the foreclosure. So we appealed the writ of possession because she never had notice of any of this. And our position is that it's all void as a result.
But the interests were foreclosed already in a prior judgment.
Yes.
Right?
Yes, they were foreclosed without notice and service.
Long time ago.
Well, not that
In
long
litigation
ago.
terms, right?
Well, more or less, but we appealed that case too, but the writ of possession, which ejected the sister from the house, occurred, you know,
At that time, your client's interests weren't represented.
Right, correct, that's correct.
Right, so, but I'm saying, but they were, as a matter of law, I mean, as a matter of that judgment, they were foreclosed.
I disagree with that, I think.
Well, I'm saying, but so how do you, but the point is now, you're not a party below. How can you make yourself a party here on appeal?
Well, yeah, that's a weird thing, because we weren't really sure about that. What they were, the whole party's named are crazy anyway, because they're suing dead people and in a state, and there's no PR or anything like that. So we didn't know whether or not our client fell into one of these categories. If you look on the record, page 18, the style of the case: unknown spouse, heirs, divides it. Jesus,
This is the point, like a foreclosure, I'm just kind of, is that it's all, once it's the final judgment, that everybody's, it's all foreclosed, right? Everybody's interests are.
No, I disagree with that. If you don't have notice, the.
Right, how do you remedy something like that?
Well, you void the sale.
Appeal a case to which you're not a party?
Well,
Essentially appeal a foreclosure judgment to which you were never a party? Isn't there some other way to undo that?
Well, we could file, yes, we could file a circuit court case, a collateral attack on it, but the thing here is.
Relief from judgment, or can you do that?
I'd rather file a new case, just personal preference, because the county court was not really equipped to deal with complicated matters, and I didn't think it was even in the correct court to begin with, because it was a homestead, and we argued there that circuit courts had exclusive jurisdiction over homestead, but the problem here is they named the plaintiff, appellee, named, you could say, there's one argument that we could make, because we weren't really positive about this, but we thought our client might have fallen into one of these many categories of people named as defendant.
How would they have known? How would they have known about your client?
They could have, well, they probably should have.
She inherited this property pursuant to the will.
Yes.
That was not probated.
Yeah,
It was not probated, no.
so how would they have known about your client, and if it wasn't probated, how was it established that your client owned the property? Other than the will, the unprobated will.
Well, they did have contact with the sister. She had the will. They could have easily asked for it in discovery of the foreclosure case.
But what obligation if they didn't have notice that there was this will with the other sister?
Well, the two record owners were dead. Now, and I've done a lot of case law where we have had to probate cases because we didn't know. You don't just, I mean, it's their lawsuit, so you, as the plaintiff,
but
you have to.
You're claiming a due process, right? Because that your client failed to get notice. And I'm trying to figure out how would they have known to notice you and include you in the foreclosure action?
They would have asked, they could have done a discovery request from the sister who they did know had the will.
Okay, so then answer for me their standing argument that because the will was never probated, your client never established ownership of the property.
Well, I don't think that was exactly their argument, but they named these categories of people as defendant. Well, we didn't. We're just saying that the unknown heirs, our client could be in the category of unknown heirs because but was never served effectively. So if she is in that category, we didn't want to waive it. And then they say, oh, well, she was in that category and you didn't appeal it. So she apparently could be an unknown heir.
Okay, so you're saying by due diligence, they should have found her as an heir?
Yes, it's fairly easy compared to some cases I've had where we've had to hire genealogists to find, layers and layers of people. So this was relatively simple of a thing to find out, but it certainly isn't our client's fault. She had no idea what was going on.
In our record, is it ever established, is the will ever probated to determine the ownership of the property? In our record.
You have no, it was not probated. You have a copy of the will, but no, it was not probated. However, the case law says that interest in the property in a twinkle of an eye at the time of the death of their mother, who was the last parent who survived, inured to the kids, to these two adult children, basically. And so under the Henry Hamill, Judge Altenberg said that it's a permissive hearing to do that in a probate case or to probate it at all. It's not mandatory. He says that Henry Hamill and in effect, even if you do probate, that's not a title transaction. That's just an order determining homestead of this piece of property of the decedent, which basically puts into words what the law already did automatically. So it already conveyed to these two daughters the minute their mother died.
So if your client had been properly served, we can get to that, what is proper service? Then she could have, absent probating the will, still have asserted her interest in the foreclosure proceeding.
It was a bill for $1,000 of unpaid assessment. She would have paid it. You don't lose a whole house over $1,000.
I say she didn't.
In unpaid assessments. She never had that
I mean,
opportunity.
I understand that it would have been nice for her to have that option. In you're saying that it would have been nice if she'd gotten notice via the newspaper or whatever and got to pay it. But what about just asserting her interest in the litigation? Would she have standing to do that? Absent probating the will and having vesting some title in her?
Well, apparently her sister did, because otherwise I don't know how they got a judgment in the foreclosure case, because they never, who would be the person? The sister is in the same boat as our client. They both inherited 50%. The will was not probated. They didn't know, they didn't understand the whole thing, obviously, but nonetheless, they got a judgment against the sister who also didn't probate the will. So I don't know. It's a very confusing
You're
case.
saying why would they even need one? If it weren't for the fact that she had standing, so to speak, as she had some interest, unprobated though it might be. That's your point you're making?
You'd have to ask them how they got their judgment, because they didn't. In my experience, when you have complicated cases like this, you do probate in a state so that you can move the title through. That was never done here.
Okay, so to your, my understanding is that one of your arguments, at least, is that the judgment is void, right?
Yes, sir.
Because there's a void role. You can parse that for me if you want, but may or may not be important. It might, if we talk about whether you could get relief from judgment, but based on failure to properly serve an indispensable party? And there's a statute that requires constructive service, right?
Well,
Am I tracking?
some kind of service anyway, it could be personal, but.
You tell us, because you're the one that has
Right,
to
well,
prove that they didn't go through.
They did not
requisite
go.
steps.
Right, that our argument in our briefs in here is that our client is an indispensable party who was never served, didn't know anything until we filed this notice of appeal for the writ of possession.
We're
which
not
excludes
appealing
her.
but I guess this is fine. I'm trying to figure this out. So you are just appealing the writ of possession. You are not attacking the judgment. You didn't seek relief from the judgment, the underlying judgment.
No, because we're of the impression that that would not have told the time to appeal the writ of possession, and that we didn't want to waive that
Well,
because.
Okay, but how can we do what you're asking us to do
Well,
if we don't do anything with the judgment that establishes the rights?
well, the second DCA in the case of Speedway Super America versus Tropic, that's the case where they say you have to go to the root cause of the problem. So obviously you have a writ of possession at the tail end of a
No,
case.
but isn't the root the final judgment that allows the lender then to have the writ of possession?
It could be, you know,
I
that's,
don't know if it's just could be, it is. I mean,
well, that's one of them. I would suggest that the root might be also their failure to serve at the front end of the case. Which
true,
could-
and that's it, that would be an action to vacate the judgment, right?
Well, this is the case, the second DCA said within the context of a challenge to a writ of possession, the court, you guys and gals have to go to the, you can't just look at an isolated writ of possession, it really doesn't tell you much. So you have to travel back in time to see what went wrong where. And I see a couple of places, certainly the final judgment. If you isolate the writ of possession itself, you know, it doesn't really give you a lot of information, although it does on the face of it show you who it was served to, the motion, the order, which were not served on the ad litem, they're gonna argue represented our client. None of that was served on them, her, the ad litem. So, but I would suggest that at the beginning of the case, when they had the ad litem appointed, they never followed the statute, 4931.
But how can we go back and how can you argue that when you're only challenging one piece of the proceedings here, which is the writ?
Because the second DCA in that
In
case I
that case,
cited
okay,
says that you have to actually do that, because what else do you have to rely on? How can you tell it's a wrongful writ of possession?
If you, sorry to interrupt you.
That's
In
okay.
that case, you're saying that they appealed from a writ of possession,
I believe they did, yes.
even though they were not party to the underlying foreclosure judgment?
Well, they're saying we were a party to the underlying foreclosure judgment by way of an ad litem scenario. So that's what I'm saying, we kind of are in a vague area here, and we had no choice but to appeal it because it would be foolish to waive it. So I don't know, did we have to intervene? You know, we discussed a lot of these things, but they named these
Let's say you were
parties.
party then, and then you had 30 days to appeal and you didn't appeal it, so
Which?
the foreclosure.
Well, she didn't know, we didn't know,
Well, I
she
know, but
didn't
then how
know.
do you, the way to rectify that is not to file an untimely appeal, right? It's to file a motion for release from judgment.
Well, or we're gonna do a collateral attack in circuit court, because I believe that's the correct court, but nonetheless. Or you do a writ of possession where the reviewing court has to look at the etiology of the defect as to why the writ of possession is invalid. Which is here, the fact that they never served our client. And the reason they never served her was because they persuaded the judge to enter an order appointing a guardian, administrator and attorney ad litem ///, you know, all three in one. But they never followed the statute where they're required to do a diligent search. They never even got a summons for the unknown heirs, didn't even bother to get one. So that is really the defect at the front end of that case.
So-
That's why I say the
Okay,
whole
so
thing's.
presumably we agreed that that was defective. And there was an indispensable party not properly, there's a party, period, not properly served. And they got a judgment against a party not served. And then after that final foreclosure judgment is final, and it was appellate rights is extinguished after 30 days. And then you're saying you're properly appealing a subsequent order, the writ of possession. And what did the judge do wrong? So what is the error there? What should the judge have done that we're correcting?
On the writ of possession?
Yeah.
Well,
We have to find an error, right?
no, you have to go back to the root cause of the problem here. That's how you get around all of that. I mean,
But you can't appeal from that order because 30
Yeah.
days is run.
well, according to
Even
the
if-
second DCA.
Which you brought up a fascinating point, that they're considering you one of the unknown parties, is interesting. So if we presume for the sake of discussion that you were a party, your client was a party, then your appellate rights were extinguished 30 days after that judgment, which understand your whole point was that how could you possibly have appealed when you weren't even served? I
Right,
didn't know about it, but so then don't we have to now, at this point, find error in the judgment from which you did appeal?
no, I mean, are you talking about the writ of possession? Well, you can, but in order to even do that, you have to go back to the
Well, let me-
root problem.
Let's go back to
Can
Speedway.
I just get one notice? You didn't ask for rebuttal time. I'm
Ah.
assuming you want 5 minutes.
5 minutes, yes, Your Honor.
You're
Sorry.
welcome to answer the question, but you're at the 5-minute mark, so I'll subtract it from your 5 minutes. Fair?
Okay,
Okay, I just want to point out, I know you rely on Speedway for that, it was an appeal of a writ of possession, that's
Mhm.
correct. But, and you keep going back to the root of the problem, well, the court went back to the root of the problem because it was a consolidated appeal on a summary judgment as well.
yes.
So that, those circumstances just simply aren't here in this case.
But it makes sense, because how do you know what's
Well-
wrong with on the face of a writ of possession when you don't realize that this person didn't get served?
I'm going to guess that they're going to say that there was some sort of publication that was made for the unknown heirs.
I've never seen one, but,
I don't know.
so you said I'm at my 5 minutes already?
Well, you're at 4 minutes
4,
now.
okay, I'll
save
take
you
that.
4, okay.
Sold.
Right. All right. I believe.
Thank you. I'm Leslie M. Conklin. I represent the owner of the property, Cathal Chauncey as trustee. I'm only going to take 5 minutes of the 20 minutes because obviously I came in representing a client after the final judgment. And point of my brief was, one, my client buys at public sale the property in 2019. Doesn't get a certificate of title because of appeals by Ms. Abadi. The same attorneys representing Ms. Abadi in the prior appeals. So my client doesn't get the certificate of title until 2020. Doesn't get the writ of possession until 2021. And it's like, this isn't how the system is supposed to work.
So the unknown heirs are living in there.
I'm sorry?
The unknown heirs are living in the property.
Correct. Well, no, Ms. Jenke never lived in the property. That was one of my points on a writ of possession. It was her sister, Denise Abadi, who was in the
So
property.
that's why you needed the writ of possession to have a.
Correct, to get her out. But here's my client's position. So we come into the case, and for the first time, Ms. Jenke makes an appearance on a notice of appeal of a non-final order granting a writ of possession. Wow, that's an unusual place to be. I don't know who Ms. Jenke is. I don't know if she's the sister, or I don't know if she's the daughter of, the owners of the property who were deceased. The point is, she comes in for the first time in the appellate case, was never below. So this case comes on an appeal.
She brought the appeal though, correct?
Correct. Ms. Jenke
She
brings,
didn't attack it in the trial court to set it aside or anything like that.
no,
But she didn't
this
say-
is the
she didn't
very
say-
first appearance
So
in this case.
you haven't had a chance to defend anything. And you're questioning standing to contest a writ of possession?
Yes,
Okay.
because as I say, she was never in possession of the property. And two, the first appearance she makes in the case at all is the notice of appeal. So this case comes on an appeal of a non-final order of a writ of possession, and she doesn't even file in her appendix a copy of her sister's motion, opposing the writ of possession, where she says, oh, this is all unconstitutional, lack of due process, and the final judgment
Talking
should
about
be
the sister who got vacated,
correct.
and she's not appealing or contesting anything at this point?
No,
It's the one not in possession that's coming in saying
Correct.
you should have found me.
right, because her motion was denied in the lower court. It came before the lower court, not just on a motion for writ of possession. It also came upon Ms. Abadi's objection. Motion to deny, vacate, writ of possession, and circuit court have exclusive jurisdiction under Florida statute section 222.10 with incorporated memorandum. So there's no transcript of that hearing, and there was a hearing, I was there, of this hearing on the motion for writ of possession, so we don't have a transcript. And two, she didn't even include in the record her sister's motion to set aside the final judgment. So here we are for the first time, as I say, with Ms. Janke, and yes, in my brief, I questioned her standing in that her claim, and that was in her amended brief, she claimed under the will. And it's like, well, a will is a will when it's probated. We don't know if there's a competing will. We don't know if the will is accurate. And in fact, the will was never admitted into evidence in this case, let alone, probated. The point being, Ms. Abadi attached the will to a notice of filing. That was it. I've never seen the original will. I've seen a copy,
Well, do you even need a will? If it's an intestate succession?
but you need something. You need to go before probate court under.
Well, I mean,
My point was she was never a record title holder.
So, sorry, Judge.
no, I'm thinking out loud, but I'll wait. If you got one tee up.
The, going to, maybe a counsel for the other appellee would be better. Or I'll ask you both, something that, Judge Smith alluded you might be interested in answering, which is, was there ever notice? I mean, in other words, she's, one of her alternative theories is that she was a party, or you're considering a party, she is an unknown heir. Was there proper service? I didn't even.
And that's why I'm only taking 5 minutes, because I wasn't on that part of the case. I came in, for the,
You're saying that this is, you're probably gonna say, regardless, this is the wrong way to go about.
exactly, that was the second point of my brief was, why do you pick this as the vehicle to overturn the final judgment? And in their amended brief, they had asked for relief. The relief was in the conclusion of Ms. Janke's amended initial brief, she asked the court to declare void, quote, the uniform final judgment of foreclosure, the judicial sale of property, the certificate of title, the order directing the clerk to issue the writ of possession, and the writ of possession itself. So the point being, I say this is the wrong vehicle. This isn't how you come to challenge the final judgment. That's what this is. She's not really challenging the writ of possession. She was never in possession of the property. The point is, she wanted a collateral attack of the final judgment. And so you pick for the first time a notice of appeal of a non-final order for a writ of possession with no record of the hearing itself on the writ of possession. Nothing in the record regarding her sister's objection to the issuance of the writ of possession. And now we're saying, oh, let's go back and review the final judgment. I'm saying there's some other vehicle to do this. You do it in the lower court. You win or lose, setting aside the final judgment, and then you bring it to this court. But you don't do it on a collateral attack of the final judgment of foreclosure based upon a non-final order of writ of possession. It's the wrong vehicle. Thank you, Al.
All right. Thank you.
Unless you have other questions, I'll defer to
No.
co-counsel.
That's 7 minutes though.
Thank you.
Miss Allison, I'd say to you, oh, wait, I'm sorry. I'm so sorry. So how much time do you need for your case?
Say maybe 5 or 10 minutes, you know.
I'll leave you
what-
10 minutes. I just want to,
Depending on the number of questions that your honors have.
All right.
Good morning. My name is Barbara Crassie Anderson, and I do represent the appellee in this case, Village of Lake Tarpon Incorporated. It's a pleasure to be here before you today. Just by way of a brief summary, the appellee, Village of Lake Tarpon, did file a foreclosure case, and there were 2 separate unknown parties, unknown heirs, devisees, et cetera, trustees, and all parties claiming an interest through Oscar Abate, who was the record title holder. He was deceased at the time of the foreclosure action. And then also the second record title holder was.
so who do you represent exactly?
I represent Village of Lake Tarpon, the
Who?
foreclosing, Village of Lake Tarpon Incorporated, which is a homeowners association which foreclosed for unpaid
So they're in
assessments.
possession, they own the property theoretically, they have the writ of possession in their favor.
Actually, Mr. Conklin's client
A
purchased the
third party
property.
purchase it.
Yes, at the judicial.
You just want the
foreclosure.
lien that's paid to be upheld.
Well, we were named as a party in this appeal, and so of the writ of possession, and so we've responded. It is attack on the writ of possession in this case, and so we responded on behalf of our client. We are happy to answer any questions that the public have.
You were added as a party, as an appellee by the other side, thinking they need to add you to have all the parties before the appellate court.
Yes,
But your only interest is you got a money lien paid off.
right, that's correct.
By
We got
that-
the
by his
final,
client.
we've got the final judgment, yes, that was entered, and then there were,
So no one's
the
asked
lien,
you,
the lien amount's been paid,
no one's
yes.
asked you for the money back.
No, that's correct.
But they're attacking the
The
underlying final
judgment,
judgment, which
yes.
is why you're here responding.
Yes,
But
that's
they're only
correct.
attacking the writ of possession in this appeal.
Well, what they claim in their claim for relief, they do seem to try to collaterally attack the final judgment, which is why we're here today.
But
Or
regardless
which is
of,
why, why my client is chosen to appear today.
regardless of the means, which we'll get to, of attacking it, there was a question that I asked your, the counsel for your co-appellee. What work was service properly effected?
Well, that's a very obviously important and interesting question. And so in this case, and again, I will speak to obviously what's in the record. One of the heirs, Denise Abate, was served because she was identified as a possible heir to the property. And then an ad litem attorney was appointed to represent any and all unknown heirs of both of the record title holders. In that regard,
Well, the style of the case below, tell me if this is wrong, was the unknown spouse of Oscar Abate. And unknown, and et cetera, whatever et cetera means.
right, so the full style of the case was the unknown heirs, devisees, beneficiaries, trustees, and any parties claiming an interest through Oscar Abate, and then the same style for the other record title holder, Virginia Abate.
Oscar is deceased.
Both, yes, Oscar Abate and Virginia Abate, yes, sir.
They were the
were
record
deceased.
title holders, they had the deed that was recorded, that's all you have
Yes,
to
sir.
go by.
Yes, sir, that's what we have to go by,
So
that's
isn't
correct.
that what's normally done on a foreclosure,
Yes,
known and unknown heirs?
yes, that's
And
correct,
you publish a notice or something, you can't serve people that you don't know about.
sure,
And you don't have a duty to find out about, then you just publish the notice, that's normally all you do. It's not like there's gonna be someone claiming a homestead interest down the road and coming back with a deed to override the foreclosure and the deed to client.
Right, that's correct, that's the purpose of naming,
She
the
alleged that
unnoticed
you
owner.
didn't publish.
So, and I do wanna respond to that, and going back and looking through the record in this case, the publication was not made. However, what did happen in this case is that an ad litem attorney was appointed by the trial court
She's
judge.
contending that that's not permissible, or there's no authority to do that, or it's improper until the publication notice.
Well, I would disagree with that, and I'll tell you why, because if you look at Florida statute section 49.31, which is which is on point for this case, there are two subsections of that statute, which are very important. The first one is that subsection 7 states that this section does not abrogate a court's common law authority to appoint an ad litem attorney. So I will certainly concede that the first part of the statute clearly says that for appointment of an ad litem attorney, and I can read the statute here, if you give me just a minute. The court may appoint an ad litem attorney for a party, whether known or unknown, upon whom service of process by publication or this chapter has been properly made. But the statute also gives the court the common law authority. There's a
Okay,
common law authority.
so the whole purpose of this, to appoint an ad litem, what kind of ad litem?
Just an ad litem attorney to represent the.
So in other words, the statute says upon whom services of process by publication of this chapter is properly made. And then, so you're saying but then the same statute says, oh, but don't worry, you don't have to do that.
Well, the same statute says that the court also has common law authority to appoint an ad litem attorney.
And then everything's just fine, you don't have to publish, you don't want to do common law and ignore section 2.
Well, this is what the base of the statute reads. And then in addition, I would also point out to the court
Did you
that.
cite a case that didn't have that to do with a different type of ad litem to support this position?
I did, well, it wasn't an ad litem case. What I did cite was the case of Rose versus Palm Beach County. And that case, it's not an ad litem case, but it does talk about the court's inherent authority to appoint or to take actions that are necessary. Give me just a moment.
I don't think anyone's disputing the court's authority, whether by statute or common law, to appoint an ad litem. The question is, do all that, it doesn't excuse also publishing notice to the world. In other words, the attorney can't receive process for people he doesn't know about. Where normally I represent you, I sign receipts saying I'll take the service. But you can't do that with people you don't know about.
Sure, well, in this case, what's interesting is if you look at the ad litem attorney's answer that was filed in this case, the ad litem attorney actually talks about the due diligence that she went through to identify.
Which didn't include
any
publication.
unknown errors.
Which didn't include publication, correct?
Correct, but she did, and she was able to identify the one unknown heir, Denise Abate, who was named as a defendant in this case. But.
So you're saying that subsection 7 says, a court may appoint an ad litem for an unknown party upon whom service of process by publication under this chapter can properly be made, or subsection 7 means, or under common law duty to appoint an ad litem, you can just appoint an ad litem and the court can just accept that whatever that ad litem's efforts were, they can assess the efforts to find them and say, and then that can be good in lieu of publication. Is there a case that supports that?
Not one that I can find, Your Honor. What I found was the case that was cited in my brief, which talks about the court's inherent authority to, the court's inherent authority to take and appoint, I'm sorry, let me just look at my notes here, I apologize. I'm sorry, thank you. In the Rose case, what the court does talk about is the court's powers is expressly conferred by law, and the Florida courts having inherent powers. And what's interesting about this case, and I'll read from the case of the quote, every court has an inherent power to do all things that are reasonably necessary for the administration of justice within the scope of its jurisdiction, subject to valid existing laws and constitutional provisions. The doctrine exists because it is crucial to the survival of the judiciary as an independent, functioning and co-equal branch of
So,
government.
so that includes the authority to appoint an ad litem for a party who hasn't been properly served, to represent its interests and foreclose them?
I do believe that under the statute, the court does have the common law authority to do that. And in the Rose case, what's interesting that the court says is that the invocation of this inherent authority doctrine is most compelling when the judicial function it issues safeguarding a fundamental right. In this case, what the appellant is complaining about is, in the underlying judgment, is a fundamental right.
But if, okay, are we talking about something that's irrelevant to our analysis here? Because she's not appealed she's not, first of all, challenged below the judgment by motion to vacate it.
And Your Honor, I would absolutely
Okay.
agree with you on that point. And she's not proved any standing in this case.
Nor even
Again,
nor even attached in the notice of appeal, the judgment.
Correct. And the other issue, as Mr. Conklin so aptly pointed out, is that all she's done is 22 months after the rendition of the final judgment is filed an unprobated will in this case.
Well, let me just do some housekeeping. We've used your 10 minutes. We've used 2 minutes on top of that. I assume you're going to divide your time 10 and 10, but you didn't use your 10. You only used.
No, I only, went to
You
use 5
might
minutes.
have gone over 5. Did you want to keep going or you're out of time? Theoretically.
No, I'll concede to Mr. Conklin if he has any other time or any other comments he has to make.
Everybody's happy with the presentation?
I'm happy. with the
Okay, thank you so
presentation.
much. All right, let's switch over to Ms. Allison. I saved you 4 minutes. It looks like that's not Ms. Allison.
I'm new. I'll let her.
No, whoever wants to do
Yeah, this
it.
is my 50th
We're
year.
in an
I'll
open court.
bow to the younger and smarter.
They're pretty. Let's go with that.
Mr. Court again. The complaint I'm hearing from appellee is that we didn't do this or we didn't do that back when the final judgment was entered. But barring omniscience or some sort of way to, figure out, to be a mind reader, I don't know, that's the whole point.
Well,
They're
before you,
being punished because they didn't serve
before you
us.
go on, you've already answered your question. Earlier you said, oh, we'll probably just file an action in the circuit court to set this aside, I presumably on the basis of fraud or lack of notice of due process, et cetera, et cetera. You're attacking a writ of possession, so you gotta stay in your lane. Your lane today is writ of possession.
Right,
These other arguments that they're raising are doing clairvoyant powers too, which we're not supposed to do.
right.
So either you're gonna say you're on the writ of possession, or somehow we have this big net that we can come in and fix all these procedural problems.
The problem with the writ of possession is that you can see on the face of the actual writ, the motion for the writ of possession, the order granting it, and then the actual writ itself doesn't have any names that would be to the service of our client. There's no ad litem, there's no anybody, there's just basically people that don't include our client. So there's not a transcript of the hearing, but again, these are facial errors, so the transcript's
It's
not
a
that.
facial error, so anytime someone looks at a writ of possession, it said unknown errors, or it says.
Right, it says, that, they didn't,
you
she
say-
never got served any of this.
Yeah, I know, but, yeah, what are we, we're in appellate court, and that's why I think to echo what Judge Valenti was saying and repeat something I said in the record before. What was the trial court supposed to do at the time it was adjudicating the possession? In other words, we are an error finding court. You have to show an error that occurred in the proceeding from which you're appealing, you could not have appealed. And I understand your point, which is that you weren't properly served, but you could not be appealing from the foreclosure in which your party's interests were foreclosed. And given that it was final judgment foreclosed all interests in favor of the HOA, what error did the court commit in this proceeding from which you've appealed?
Because on the face of the motion, it doesn't include our client, and I dispute that her interest was foreclosed, I disagree with that, but I understand.
Well, you're saying it
what
wasn't
you're saying.
foreclosed because she was never served.
Right, exactly.
But there's a judgment for closing it.
Well,
And what, so, and I'm saying,
there's a writ of possession that says.
there's also a foreclosure judgment, right?
Right,
And then so what, if you've gone past the 30 days to appeal that, what's your recourse?
well, file a motion to, 1.540, or you could do a collateral attack on it in this particular situation. Under Citibank versus Villanueva, you know, if you weren't served,
got
then
about
you're an
30
indispensable
seconds to
party.
go.
Okay, so on
30
this, the problem here is this is a writ of possession that includes who should be the unknown heirs, that was clearly by the certificate of service and by the copies furnished to section was never served on the unknown heirs or the ad litem. They're all, that is on the face of this in the lane of the writ of possession. But again, I go back to the root cause where the case law, though it is a summary judgment case, I don't know how else you would argue a writ of possession
Well, I
at
don't
this
want to
point.
interrupt you because you've done a good job of arguing today, but you are out of time.
Thank you.
Fair enough. All right,
Thank you all.
both.
Appreciate the time.
All right, ready to go, one more. We're gonna move on to the next case, folks. It's Rex Yentes and Ann Yentes versus Dana Foam, Papadopoulos, MD, and Bond and Steel Clinic, PA, DBA Bond Clinic, PA.